welcome everybody. For those who don't know me, I'm Laura Skillen, the Executive Director of the International Mediation Institute. Welcome to this edition of the IMI SIMI Singapore Convention Seminar Series. We're here today with our friends from SIMI as well as our guests. So we've got Marcus Lim, the CEO, as well as Jess hanging in the background. And I'll introduce Anil shortly. Just a bit of housekeeping first. For those who haven't used Zoom webinar before, you'll see that there's a button at the bottom of your screen or on your phone which says Q&A. So if you do have any questions as the presentation is going on or afterwards, please do insert them there in the Q&A. Perfect, but with no further ado, I'll introduce Anil Xavier. Now, Anil is a big friend of IMI and I believe of SIMI as well. He's IMI certified. He also runs the Indian Institute of Arbitration and Mediation, which has an IMI qualifying assessment program. And of course, he was a big partner in the Global Pound Conference run by IMI a few years ago. So welcome, Anil. I'm looking forward to hearing what you have to say.
Thank you, Laura, and thank you, Marcus. What I would do is see the entire segment because the topic is on India and the Singapore Convention. What I thought of doing is I will probably take this into 4 segments like this. That is, first is mediation in India. Then we'll go to the relevance of Singapore Convention very shortly, and the present scenario and mediation, and finally the way forward. So first I'll go to the mediation in India for people who are not very clear about what is happening in India, or what is the mediation scenario in India. See, primarily the modern mediation movement, of course, mediation was there from centuries in India, but the modern mediation movement is broadly divided into 3 segments. The first segment is the people. In fact, in Lok Adalat, it is governed under an act, in fact, it is called the Legal Services Authorities Act. And any court, because the court can refer any matters pending before it to the Lok Adalat, and the Lok Adalat will have jurisdiction to determine or arrive at any compromise between the parties in any pending case. That is one thing. And also for which matters are not before the court, also they can be brought before the Lok Adalat. So whatever the Lok Adalat makes a compromise between parties through mediation, it has the same status of a decree of a civil court. That is the first limb of mediation happening in India. The second one is under the Arbitration and Conciliation Act of 1996, where in 1996 the term mediation, or we can call it as conciliation, was first used in an act, and the first time a statutory recognition was given to a mediation, mediation provision, and a settlement agreement made under the Conciliation Act under Section 74. The settlement agreement is given the same status of an arbitral award. And the third one, of course, is the Code of Civil Procedure, which is pending, relates to matters pending before the civil courts. And an amendment was brought in 2002 by inserting a Section 89, where the court was given power to refer the parties to any sorts of ADR, like mediation, conciliation, arbitration, or Lok Adalat, in whatever manner the courts think, and which is comfortable for the parties, the court can refer the matters to mediation. And once the matter is resolved through mediation, the matter is taken back to the court, the terms of settlement is recorded, and a decree is drawn by the court itself. So now, if you look at the mediations happening broadly, these are the 3 types of mediation that is happening. And now we will just go to the relevance of Singapore Convention, and then we'll see how it is related with the mediations happening in India and how it can be made use in the mediations in India. So as we all know that the Singapore Convention, which is of course the proper name is the United Nations Convention for International Settlements, Agreements resulting from mediation, was adopted in 20th December 2018 and was open for signature on 7th of August. And on 7th of August, India and other countries have signed it. And the convention was adopted basically understanding the requirement of mediation in international trade or commercial matters, and a framework for regulating mediation and for enforcement of settlement agreement was found to be required. And therefore this convention was made. And as of 12th March 2020, 52 states have signed and 3 states have ratified it. In fact, Singapore and Fiji have ratified it on 25th February 2020, and Qatar has ratified it on 12th of March 2020. In fact, the relevance of the 3 ratification assumes very importance because as per Article 14 of the Singapore Convention, only when 3 countries ratify it, then 6 months after that last ratification, the convention, the Singapore Convention comes into effect. Therefore, right now, if you look at 12th March 2020, the Singapore Convention would actually come into effect on 12th September 2020. And let us look at the scope of the convention, because primarily the scope is related to settlement agreements resulting from mediation, where at least 2 parties are from different states, having business in different states. But we need to look into certain aspects which the convention does not apply. That is, it will not apply to disputes arising from consumer, family, inheritance, or employment disputes, or disputes which are matters in which mediations are approved by the court or concluded in the proceedings before the court, or mediation settlement agreements which are regarded as enforceable as a judgment or enforceable as an arbitral award. So these 4 categories broadly will not under the convention. So we need to look now, we will go back to the Indian scenario, because I've told you that there are 3 basic categories of mediation happening in India. And if you look at the 3 categories, all the 3 categories prominently does not come under the purview of Singapore Convention as it stands now. Because as I said, an award made in local Adalat, human agreement having the force of a decree of a civil court, will not come under the purview of Singapore Convention. And if you look at the settlement agreements made under the Arbitration Conciliation Act, even then, even there, it is under Section 74, it is deemed to be an arbitral award. So it is executable as an arbitral award, and therefore it will not come under the purview of Singapore Convention. And the court-annexed mediations which are happening, see, in fact, the majority of the mediations happening in India will come under the category of court-annexed mediations. And in those mediations also, it is taken back to the court, and the court makes it as a judgment or a decree of the court. So those type of matters also will not come under the purview of Singapore Convention. As most of the settlement agreements which are made in the present mediation scenario in India may not, or which will be the outside the purview of enforcement under the convention. So what we need now is an act which will define mediation in its proper sense, and which will also incorporate the terms of the convention to make it enforceable under the convention. So the government of India is already considering a mediation law, and in fact a parliamentary subcommittee is already working on it. And even the Supreme Court has given some guidelines, and a committee was also formed under the Supreme Court to look into those aspects. So only after a substantive mediation law is made, and after the convention is ratified based on that law, India will be getting the benefit of Singapore Convention, enabling success of mediation in international commercial disputes. So till such time, what we are doing is we are adopting the AMA protocol or the MEDOP protocol, whereby when a settlement agreement is made, or when a dispute happens, we invoke the arbitration clause and take it to mediation. And once the settlement agreement is made, we are bringing it back to arbitration and making it an arbitral award, thereby making it enforceable under the New York Convention. So this is how the present cross-border mediation is mostly happening to make it enforceable in international scenario. So now we will go to the present scenario. Of course, we are all here, and most of the webinars are happening because of the present scenario. Because the present pandemic of COVID-19, see, first of all, there is no doubt that it's a public health crisis. But more than that, as more than the health catastrophe, I think it is definitely going to disrupt other spheres of life also. Definitely, we are going to face one of the deepest recessions in history, and consequently, the business disruption or the contractual disruptions are going to happen. And we are going to definitely see a different concept of justice and different access to justice during the post-corona or a post-COVID period. And primarily because during the post-COVID period, when there is an economic recession, people will not have the luxury of time and money to engage into regular litigation or arbitration of commercial disputes. Because companies, it will not be economically feasible for the companies to engage in long drawn litigation processes or spending huge money or spending a lot of time. And even if after a prolonged process they win a legal battle, it will be difficult to execute the decree or award, as many of the debtors or the judgment debtors will be facing bankruptcy or insolvency. So the best possible option would be to resolve disputes by mediation. Of course, by mediation, you will be able to resolve disputes at this kind of this in a distressed economic situation. It is not only in a manner beneficial to you or to the parties, but it also benefits the global economy. But the $1 million question is, why should a party opt for mediation? Because see, we are, of course, all of us are trying to promote mediation, bringing down the benefits of mediation, and IMI is, it's one of its mission is to promote mediation. But why should people opt for mediation? So let me put it in a different manner. See, primarily, if you look at basic human instincts, there are two instincts. One is my hunger matters first, and the second one is your hunger matters first. If you look at the business world, normally the instinct is my hunger matters first. And even if your company has a very considerate policy, your hunger only matters if you satisfy my hunger. Or after I satisfy my hunger, I will consider your hunger. This is how we are designed. But of course, what I feel is definitely there's a third option. That is, by satisfying your hunger, I can outgrow my hunger. But the problem is, this entire statement is considered more of a divinity or merely a theoretical aspect. Because we would wonder, if I satisfy your hunger without satisfying mine, then how would I survive? See, it is a question of prioritizing. If we are prioritizing our hunger or benefit without considering the hunger or benefit of the other, then the entire process is like a battlefield. On the other hand, if you're considering the benefit of the other side also, thereby satisfying their goal also, then the process is like a playground. See, now, if you look at the two distinctions, one is a battlefield and another is a playground. An adversarial process like litigation or arbitration is similar to a battlefield, and a consensual process like mediation is like a happy playground. And the outcomes can be totally different because we are engaging with the other side and talking with the other side to find out a resolution. Fundamentally, I should say it's a matter of belief. See, we can probably look at it like this. See, belief, process, and outcome. See, suppose my hunger matters first is the belief. Then the process is at the battleground, and the outcome, even if you have a very good case on merits, it is prosperity without peace, you can say. Suppose your belief is your hunger matters first. Then the process is like a playground, and the outcome would be prosperity with peace. What I feel is, with the present condition or with the present phase of the world facing the pandemic of COVID-19 and the consequential economic slump, no business can survive with the belief of my hunger matters first. In the present scenario, businesses would need cooperation and partnership to survive this crucial period. This would be the best chance of creating prosperity with peace. And that, I would say, that would be the best outcome if there is a positive outcome from COVID. And the way forward. In the present situation, with travel restrictions and social distancing rules, it would be very difficult. Maybe it may last for maybe for 1 year or maybe for 2 years. We don't know about what would be the future like. But the prospects of bringing everyone connected with a dispute along with their advisors or lawyers to one single place to redress the dispute can be very difficult. It is not only because of logistical restrictions, but it can also be due to financial constraints. So the way forward probably would be online or virtual. So it could be online mediation or virtual mediation. In fact, we in the Indian Institute of Arbitration Mediation, we had developed an online platform or a mobile application called the PeaceGate, by which a party can initiate mediation online, appoint mediator online, issue invitation to the other side, conduct mediation process online or by virtual meeting, execute the agreement to mediate online, and even execute the settlement agreement online, and also sign the settlement agreement online. In fact, it is beneficial, or it is beneficial not only for the parties to go in for mediation, it also helps the mediators to conduct mediation with automated and AI assistance to make minimal errors with high efficiency. In fact, the Singapore Convention also supports online mediation, because as per the definition of settlement agreement, it says that in a settlement agreement, it will be considered as in writing if the content is recorded in any form, including an electronic communication. And even going further in the convention, it says the requirement that a settlement agreement shall be signed by the parties and the mediator is also met in relation to an electronic communication. So the Singapore Convention actually provides support for online mediation. And at this time of travel restrictions and other issues, for international mediation, definitely I think the next year we would be looking at international online mediation. So the basic, or the final question I would like to pose is expected of us as professionals or followers of mediation. I know, of course, all the participants in this webinar has got an interest in mediation. Otherwise, we won't be participating in this. So what should be our role during this pandemic period? I know, see, webinars are being conducted, but see, just webinars are not sufficient. You may have to do something more. So what would be the role of IMI? What should be the role of the mediation institutions? What should be the role of mediators and area professionals? See, I think we need to be proactive on this. So now I think we will open up for discussions, and I would like to have your suggestions and comments on this, and maybe we can have questions on this. And you can also give your comments in my email ID, which I've shown in my screen.
Well, I think there's a couple of questions in the Q&A section if you'd like to take a look. Would you prefer I read them out? Yeah. Are you happy to open them up?
Now, one question is with respect to why the government has not ratified the convention so far. See, the convention, I think it clearly mentions that, see, if you look at the convention actually does provide for the process of execution or enforcement of a settlement agreement. It says that settlement agreement has to be enforced according to the procedure laid down in the law of the country. So we need a mediation act to support the Singapore Convention, and as soon as a mediation act is made, I think the government will be ratifying the convention, because I think the delay has caused because of this pandemic. Otherwise, it would have been over much earlier, because I had attended the parliamentary subcommittee meeting about, I think, 3 months back, and they were almost ready with the thing. And the Supreme Court, as I said, the Supreme Court has also formed a committee, and I'm a member in that committee, and we were discussing and finalizing the Mediation Act. But now everything has been quarantined. When you foresee the Mediation Act to be passed, I think see, we are finalizing the act, and it should be ready in about it would have been ready much earlier, but now I think during the lockdown we are coordinating with that, and we would be probably coming out with the act maybe in maybe in 1 or 2 months it should be ready, and I'm sure the ratification should happen by the mid of this year. Another one is with respect to, but I think it may not be squarely applicable in the topic of discussion that we're having on Singapore Convention, because the question is when we are having a virtual mediation, how can you look at the seat and venue of arbitration? Because I think the question of seat and venue applies only for arbitration. It may not be a very strong point in mediation, because the parties are consensual and they're coming out with a settlement agreement. The only point is where you make the settlement agreement and what law will be applicable, that will have to be agreed upon. So unlike a seat of arbitration, that may not be squarely applicable for mediation. Another one is with respect to how a mediation agreement is brought to the arbitral channel for an arbitral award. See, that of course, it's very popular in many of the countries. Of course, Singapore, SIMC is also doing it under the IMI protocol. See, fundamentally, it is an extension of the MEDART clause, but the MEDART clause has got a defect because the moment the mediation settlement is done, the arbitration is invoked after the settlement is made. So practically there is a defect because the arbitral or the arbitration agreement is invoked when there is no dispute. So to overcome that issue, the ARP-MEDART protocol or the AMI protocol was suggested. And then because the arbitration clause is invoked when there is a dispute, and then the arbitration is stayed, and then you take it to mediation, and once a settlement is made, you're bringing back the resolution to the arbitrators to make it as an arbitral award, so that it can be executed under the, if it's an international one, it can be executed under the New York Convention. So that is basically the AMA protocol. Rangaraj was asked whether there is any provision for breakout rooms in your app. Of course, we have virtual rooms. The mediator can create any number of rooms. The general room will be all the participants, the lawyers, the parties will have. It will be only the parties whom the mediator wants will be in the caucus room. So you have virtual caucus rooms also in the app. What is the timeline for circulating the Mediation Act? That depends because the parliamentary subcommittee, we have to submit the draft legislation to the parliamentary committee, and then the parliamentary committee will be making it open for comments of the public. You see an issue with Section 89? Of course, Section 89, it does not take away the party autonomy because it is only after the settlement is made by the parties that the court makes it as a decree. So it doesn't take away the party autonomy because the decision making is still with the party. But of course, why I said that is since under Section 89, it goes back to the court and the court makes it as a judgment. It comes outside the purview of the Singapore Convention because the Singapore Convention settlement agreements does not take into consideration settlement agreements which has the power, which has the characteristic of a judgment or an award. And what would be the privacy on online processes? See that in fact, we are making it very secure because nobody can enter the rooms or even the general rooms, nobody can enter. It will be on invitation and the mediator or the administrator will have to admit your entry. So the process is very secure, and even the signatures and the online signature which you do in your settlement agreement is also secure. And certain security measures are already mentioned in the Singapore Convention about online mediations. See, when you enforce a settlement agreement which is made online, there are certain supporting documents that you have to file along with the enforcement with the settlement agreement. In fact, we have incorporated all those security measures in the application so that once a settlement agreement is made, all the backup measures of security are also made along with it. Because as I said earlier, in the PaceGate app, it is mostly the automation and artificial intelligence also put into place. So the life of the mediator is very easy because you have to only record the terms. When the parties have finalized the terms, you have to only record the terms. And at the very beginning, it will mention whether it's a domestic mediation or an international mediation. And if it's an international mediation and a commercial mediation coming under the terms of the Singapore Convention, the settlement agreement will cover all the legal requirements of the Singapore Convention, and the settlement agreement is automatically generated. So the mediator do not have to write the settlement agreement at all. You have to just mention the terms and ask the app to generate the settlement agreement. So that the app generates automatically the settlement agreement complying with the legal requirements, whether it is international or whether it is domestic. If it is domestic, it covers all the legal requirements which are required under the domestic law. If it's international, it covers all the requirements which are mandatory under the Singapore Convention. Any other question, Laura?
Yeah, can I interject with a question actually? Because we're talking a bit about mediation laws in India, different applicabilities there, and the needs we have to change mediation in India. But thinking though about the Singapore Convention, I mean, what benefits or opportunities do you think signing the Singapore Convention would have for India?
No, see, definitely, I think. See, of course, I'm not taking away the leadership of Singapore here. See, Singapore will definitely continue to hold a lot of mediations globally. There's no doubt about it. But see, if you look at parties, the parties who take advantage of the Singapore Convention would probably be India and China, because see, most of the business contracts, most of the businesses are happening in many countries where international advantages of, one of the see, what I can say is, if mediation, maybe after 5 years when we are talking about mediation, and then even then we are talking about promoting mediation, that means mediation is a failure. So, but if at all mediation becomes a failure, then the responsibility, I think, would be on India and China. Because in spite of a Singapore Convention, if they cannot promote mediation as a very strong alternative for business community, I think it will be the responsibility of China and India, because they are holding much of the contracts.
And so we've got a question here as well from Yin Chen, who says that, I recall Anil said the arbitration agreement is brought to the arbitral channel for an arbitral award. Does this mean that there is no mediation settlement agreement but arbitral award in India at this juncture?
No. See, the thing is, if a party is invoking an AMA protocol or an AMA arbitration or a mediation clause, because AMA means arbitration, mediation, arbitration. So if the party invokes that, he can have the option of retaining it as a settlement agreement. Because if you're having a domestic arbitration, as I said, in private mediations, in India, we are utilizing the Arbitration Conciliation Act. And as under the Conciliation Act, even a settlement agreement made out of mediation will have the same status of an award. So we can execute it in a court like an arbitral award. So there is no problem. But if you look at an international scenario, you don't have that benefit, because a settlement agreement will still continue as a settlement agreement. It will not be enforceable. So what we did is, we will invoke the AMA protocol, so that you invoke the arbitration clause first. Then the arbitral tribunal stays the arbitration process, send it for mediation to a different mediator. So the mediator, if he can resolve the matter, he sends it back to the arbitrator if the parties want to make it enforceable. So it comes back to the tribunal, and the arbitral tribunal will convert it into an arbitral award. So there is no settlement agreement there. It's only an arbitral award. So then it becomes executable as an arbitral award under the New York Convention internationally.
So Anil, I'm going to jump in.
Yes.
Sort of the conversation, keep it basically around the SCM, but in a slightly different time space. So if we sort of put ourselves in a situation where India has already ratified the convention, right? And there's legislation to ratify it. What else do you think you would like to see next coming out from India after this? So we're in the future right now. What do you think you would like to see? You know, it could be your dream, it could be your ideal, anything at all. Just in your view, what do you think is the next thing that should come out from India?
No, definitely companies, what I feel is this lockdown period was a time for reflection. So many companies, as I said, see, you have to collaborate to do business now. You cannot compete, or you cannot just go and fight and get an award or get a degree and go on with business. Because right now, see, let us look at this force major, because now the next maybe 1 year, most of the contracts will be looking at the phase of the force major. See, once you invoke force major, then your business relationship is lost, because you are invoking your protection, but you are not going to continue with your business. Is preserving the business, because if you are going to cancel or frustrate that contract, to get a new contract during this period would be very difficult. So many companies would like to preserve their contracts, but do not get into legal problems. So the only option available for them would be mediation and not arbitration, because if you're going for arbitration, you're not going to continue with business and again protect with your force major clause. So I think many companies will do that, and I hope many of the business community, see, it all depends on how we are going to promote this concept, because see, this webinars, see, the problem with webinars and these conferences are all of us who are in the field, like mediators and mediation lawyers or mediation institutions, are always participating, and the business community rarely attends these type of conferences. So how do we reach to them to tell them, see, this is something that is beneficial for you, it is beneficial for your business. So I think I would like to know Laura's view on this, because IMI is formed to create awareness.
Absolutely. I mean, that is, of course, part of our mandate, and of course, part of the reason we're doing these webinar series as well, so that we can not just shine a spotlight on mediation, but also the possible implications for the Singapore Convention in particular. Because at the end of the day, I mean, I think you sort of mentioned earlier that it wouldn't really make a difference, and that if this is not uptaken, it could lead to failure. But I think that one of the really valuable things that the Singapore Convention actually adds, whether in India or elsewhere, is that sort of polemic propaganda style assurance that something will happen, that mediation is successful. And so I think, yeah, it could be a really interesting opportunity, definitely.
Yeah, that's true.
Great. And we've got, in fact, we've got a very much related question here, and please forgive me if I pronounce your name incorrectly, but it's from Sarthak Babar. And he says, do you feel the Singapore Convention can help mediation just as the New York Convention helped arbitration?
Definitely, because the arbitration has become the so-called arbitration only because of New York Convention. See, if the New York Convention was not there, arbitration would have just confined to certain territories. It would not have grown global. See, now, when you have 195 countries or maybe 190 odd countries, and we have only 52 countries signing the Mediation Convention, and you have more than about 150 countries signing the New York Convention. So the time we cross 100 numbers of countries signing the Mediation Convention, and the time when the countries start ratifying it, I'm sure that maybe the next decade will be the decade of mediation and not arbitration.
Great. And actually, there's a question here for IMI, so I'm going to answer it really quickly. I'm sorry, I've definitely pronounced it incorrectly, but they've asked, what would be IMI's position on online mediation via the existing mediation protocol? And so I understand that to mean what is the position of online mediation as opposed to normal mediation processes. So please correct me if I'm wrong. And it's really interesting. I mean, IMI have actually developed standards for online mediation. You'll find them on our website, and we will shortly be rolling out specialization. So we call it a specialization on purpose, because we do see that absolutely you can do mediation online, but there are different things that need to be taken into account. There are different skill sets required. There are different platforms required, and different knowledge as well. So in the context of the coronavirus crisis, we've seen a lot of instant experts in the field of online mediation, which can be problematic. And of course, we want to avoid that. So I do absolutely encourage you to have a look at what's there on the IMI website. Keep an eye for a rollout of specialization in a couple of weeks' time, fingers crossed, maybe even sooner. And as well, check out the video we did with Menon Schoneville a few weeks ago. He talked about some of those basic principles of the shift from mediation face-to-face to mediation online, as well as the limitations. All right, so I think that's the substantive questions answered. There is actually just one more from Joyce Aluok. So I think a bit of a clarification. So you said that India has no mediation law yet, and do you think that is why India has not yet ratified?
No, there are two options. One is a settlement agreement without making it as an award under the Arbitration Conciliation Act. But when you have such an enforceable thing, most of the people prefer private mediations to be done under the Conciliation Act so that it becomes enforceable. But you can always have private mediations done as a pure settlement agreement. It is possible. But the problem is, unless you have a law which specifies the enforcement of such mediation agreements, we will not be able to take hold the conditions under the Singapore Convention. So we need to have a law which will apply for settlement agreements made in other countries. And because the difference is, if you look at the Singapore Convention, unlike the arbitration, the institutional model law on arbitration, the difference would be probably the challenge of the settlement agreement, because you don't have a specific provision for challenging the settlement agreement. Only when you enforce it, when you apply to the court to enforce it, the court looks at the challenges which the party can raise. So unless the substantive law of the country makes a provision for that, it will be difficult for a country to enforce a settlement agreement. And of course, whether India ratifies it right now or the advantages, now the Singapore Convention will take into effect only settlements made after September 2020. So we have time, because since Qatar has ratified it in March 2020, the only settlement agreements made after the coming into effect of the convention, that is September. So only for settlement agreements made after September 2020, this convention would apply. I'm sure that India would ratify it much before that.
Great, thank you, Anil. So I'm going to jump in once more and ask another question of you. So from your perspective, what would be your hopes for mediation in India? What will it look like 10 years from now in your dream?
It's for me?
It is.
Laura?
Yep, it's from me to you, Anil.
Okay. So see, the thing is, in fact, Marcus was telling me he was in lockdown for almost 2 months. I'm sure after the lockdown is over, he would still like to continue in his home with a virtual world and continue to do some work. So what I feel is this lockdown or this entire pandemic for 1 year would change the attitude or change the way in which we are going to function in the future. So what I feel is a regular mediation or arbitration where parties actually travel and meet face to face would be an alternative, and online or virtual would be the option that people would prefer after you are faced with such an option in the next 1 year, because then it becomes the custom, it becomes the new normal. So I think mediation would grow fantastically well if you are taking, because see, the advantage of online is not just convenience. It takes away a lot of expenses, because the traveling expenses of the parties, the boarding expenses of the parties, everything is taken off in an online platform. So it is much, see, suppose IMI, let us take this webinar. Suppose you wanted to conduct a regular conference like this. See how much time, expenses and inconvenience would have been cost to everyone. So now see, it is just in a click, you're all together and we can convey whatever we want. So I think mediation, it would be wonderful if, I think arbitration is also going to face the same thing, because virtual hearings are going to happen. And I think mediation can take this opportunity to grow, because it would be much easier for them. And since the time is also very, very short for resolving matters, comparing with arbitration and comparing with the travels that you have to do. And I think every person should opt for mediation, at least as a trial during the next 1 year.
Super. And so we've got one more question here as well from Sathak, who says, on a ground level in India, mediation is seen as a formality and not actually as a dispute resolution process. Can this convention help to make the situation better?
See, it all depends on your attitude, because see, if you're forced to do something, it continues to be a formality. If you do voluntarily something, it becomes a pattern. So the thing is, as I said earlier, most of the mediations happening in India are quote annex mediations, because you are compulsorily asked to go for mediation, and that becomes a formality. But if you understand the benefits of mediation and you understand that mediation is actually value addition to your business, then it is not a formality. It's a matter of option, or it's a matter of your tool. So it would change. Definitely, it would change.
Perfect. All right, Anil, I think that brings us to the end of our session. It's only a 45-minute webinar. So unless there's anything else you'd like to add, I'd like to, again, thank you very much for attending. I think we've learned a lot and certainly gained some insight into the situation on the ground in India. So thank you very much.
Thank you. Thank you, Laura. Thank you, Marcus. And thank you to all the participants.
Thanks, Anil. Thanks, everyone.
Yeah.
All right. Thanks, everyone.
Bye.
See you next
Bye.
time.
Good night. Well, good morning, wherever you are.
Yeah, just bye.